The students read about that case you had involving the products liability case, where you had a choice whether to file in state court or to, the way it was presented on paper was that you had a mentor who was a more experienced lawyer who had said to you, well, I could help you in federal court when you do your first federal court trial, and this opportunity came up and you chose not to pursue the mentor's offer. And you know, I have my students do reflection papers on this whole scenario and explore the different values at issue. Obviously, whenever we're talking about lawyers and clients, we're going to look at the client's interest, then we look at the interests of the judicial system, we look at your interests. The model rules say the lawyer can take into account their interest in remaining an upright person and to make a what does it say, an honest living or something like that. Yeah. So the students really had some questions about your judgment on this. I want to put it delicately, but a lot of the theme of the papers that I've read was that you seem to have put your own personal interests ahead of the clients. So
how dare they?
Okay, well, can you explain the process by which you ended up choosing to represent the client,
Yes.
take it on your own in state court, and then I'll let students ask some follow-up questions.
Okay, well, a bit of real world advice from a new associate who's been plugging it out for a few years. So take this for whatever you think it's worth, but a more senior attorney, seasoned attorney, experienced attorney is probably going to translate many, many times to less work for them, a lot more work for you when you partner up. So keep that in mind. That's a real world lesson. So I'm confident in state court. Do well with juries and I do well with judges. This mentor of mine does very well with judges in federal court, does a lot of appellate work. Doesn't do so well with the jury. Very dry person, very intellectual person, doesn't connect well with the jury. So that was a concern to me. Another concern.
No, we didn't hear that. That was a what? That was a concern. Concern, okay.
Concern. Because my client, as you know, was guaranteed the right to a jury trial in civil cases in Dallas, and we asked for one. I spoke to my client. They definitely want a jury trial. And if they want a jury trial, then they need an attorney who's going to connect with that jury to get the best verdict for them. Another concern of mine was, obviously this is a contingency case, which means I don't get paid a dime unless I win. And I'm going to put literally hundreds of hours into this case. And I know that my mentor, while a very decent person, is not going to go through discovery with me, is not going to respond to discovery, draft responses, write the briefs. All of the grunt work will be my own. What this mentor will do is be briefed a couple of days before the case, show up to federal court for this 1 or 2 day, maybe 2 to 3 day trial, and walk away with a hefty sum if we win. And that's a big if with this attorney. So that was another thing I took into consideration. The third thing I took into consideration, I know that my client's expenses are mounting up, but the rules do allow me to pay for the court fees, which I do, build that into my contingency fee. I write these down because there were several pros for this. So this is the main thing though. Discovery in a case like this, in a rocket docket, I'm not going to survive summary judgment.
You're talking about the federal court would be a rocket docket in most places.
In most
compared to
places,
state court.
district, but, yeah, sure, federal courts, as you know, they don't suffer fools. They're not gonna go for discovery battles. You can beg and plead for more time, and you're really rarely going to get it. They're not interested in that. It's about efficiency. And a lot of times, that's a great thing for you when you've got, you can do such a thing where you get all your ducks in a row before you file the case. Well, in this situation, that's not what's happening. I need more discovery. I need time to go through the thousands and thousands of documents that the opposing counsel is going to bury me with, so that I can find that one or two needles in a haystack. My mentor is not going to help me with that. So at the same time that I'm doing these hundreds of hours of work for this case, I'm not making any money on this case. And it's also not the only case I'm working on. So even if I were in federal court, I've got to devote time to my other cases, or I'm not going to get paid anything, ever. So those are the realistic
And also your clients are not going to be protected, served, etc. if you're focusing exclusively.
Well, I provide summary judgment, even if, it's, what's the point? Because it is still going to take more time, even if you go on appeal, write more briefs, whatever I need to do, that still translates to more time. So for me, after weighing the different factors, and especially after considering the amount of work that it's going to take, my client won't be hurt by the fact that I filed in state court. It doesn't make an attorney less competent to choose state court. You have to, like Professor Madison has said, weigh the pros and cons. I've just finished a case that's worth $500 million potentially in fees in a district court in Dallas. So state court is not it's not the low end. It's a different means to an end. And if you know your judges, you know your jury pools, and you can weigh those things out, it's just a different way to get there. And for me, I wasn't willing to split my contingency fee just to have my first experience in federal court. That case will come up. I'll have another opportunity. This wasn't the right one.
Okay, well said. Now I'm going to let the students follow up with any questions they have. Okay, go ahead.
I don't know if she can hear me, but
I can hear you, and I apologize for this massive time of my
I'll walk up
so
there.
that's fine. That's fine. She can hear me. So, is it ever a concern of yours taking a case that could potentially be filed in federal court? Is it ever a concern that the defendant might remove it and leave you in the same situation, but just less prepared? Because you said you got to front load all the work on a rocket docket, right? You got to be ready to go from day one. Well, what if they removed a federal court? Doesn't that thrust you into the same situation you're trying to avoid, where you might be again overwhelmed with discovery that you can't get through in time if they remove?
Well, I mean, they've got to overcome the hurdle of why they're going to push it back down to state court anyway, if they've got diversity. It's a chance you take with every case that you file when you have an opportunity to file in federal court. That's the reality of the practice. You sit around with everybody else and you talk about, we basically make a pros and cons list. Who knows this judge? Who knows the federal court judge? Who knows the state court judge? What do they like? What kind of verdicts do they give? What kind of jury instructions are we going to get for this type of case? That's an everyday part of practice. And so, the advantage you have as a new associate sometimes is when you're fighting the big guns as plaintiff's counsel, and you've got literally a legal department of some corporation, and you're talking 10, 20 people, along with they oftentimes they're going to hire outside counsel. So you've got mega giant law firms along with mega giant corporations sometimes. And one of the advantages is they don't think that you're competent. They wonder about your years. I cannot express to you enough the arrogance of most attorneys who have been practicing. So I don't mean to be unkind, but you will encounter it, and you will encounter that often.
What's a way you could ensure that this case stayed in state court? You're dealing with a manufacturer, right?
Right.
Okay. If the product was
Well,
bought
I mean, if
in
they've got an
Texas.
office in that court, the products in the stream of commerce, or you want to use the state court or federal court?
A dealer, isn't there gonna be another party that you could sue?
Sure, the person who sold the product, and that's
The-
probably to be your local, your local.
And then we've got this issue, that, remember? Diversity has a couple of hurdles, federal question has one, the well-believed complaint. Removal has tons of hurdles, one of which, a major one of which, is the in-state removal bar. If there's
Right.
one defendant who's a citizen of the state in which you sue, so I know when I was practicing.
Right, I think this was a federal question issue, wasn't it? It wasn't a diversity, federal court. Why are we in federal court? I don't remember.
It was
Oh, it
diversity.
was diversity, okay.
Yeah, so I think you could lock it into state court like you want to. And you think apparently that's in the best interest of your client in this case.
I do in this case.
Yeah, and I've been preaching to the students, I'm glad you're giving the counter side, that always put it on the fast track. Push for your client. If you're in state court, get a pretrial order that sets a trial date and sets deadlines.
Right.
Are you saying not to do that?
No. I'm absolutely saying be efficient and be mindful of the fact that your poor client has bills mounting up. At the same time, what is the point of being efficient if you're going to the ability to go through the literal time in the day to go through the discovery?
So you're saying that in a case like this, when you know you're going to be dealing with a product manufacturer, they're going to be lawyered up with, what's one of those big Dallas firms?
Oh gosh, Gardner Wynn.
Yeah. Okay. Well, they're gonna unleash lots of discovery. You're going to be dealing with that. The court's not going to completely cut them off. You can seek protection, but you're saying that the fast track may be like a 2-year trial date versus a 1-year trial date or a 3-year trial date. Is that what you're saying?
That's exactly what I'm saying. And even to your point about discovery, it's not just what they're going to send to you. It's the nonsense that's going to go back and forth as far as what your discovery requests are, and did you ask them properly? Did you ask for the right thing? And then realize you're going down the wrong track.
Nonsense? You mean lawyers engage in nonsense? What kind of nonsense?
The game. I think that's the thing. You'll find the lawyers who are ready to work on the best interest of their client, and then you'll find the attorneys who know that this is their cash cow, and they will draw it out and draw it out and draw it out.
And what kind of objections do you get?
In discovery?
Oh.
Overbroad, relevant, same old. They're boilerplate objections, which is this state judge that I've been working with actually has adopted. There have been some new rulings that say no more boilerplate. You be specific. What are you objecting to? So that's helpful.
Bully for him or her? Her. Ah, you caught me. Bully for her. Yes. Any other questions? Okay, go ahead, Rachel.
Miss Bailey, how did you present this to your client? If you did, I wanted to ask if you even brought up to your client the option of going into a federal court as a possibility, and then how did you explain to them what your motivation would be for why you really thought state would be best for them?
I try to be extremely honest. Most clients are not super sophisticated about these things. So you have to educate them, and so that's where your ethics comes in. When you're educating them, what are you leaving out? What are you emphasizing that maybe you're overemphasizing to get them to give you, the answer that you want? So I'm honest, and I explain the pros and cons, exactly as I have done to you. Contingency fee means, pretty much everyone knows what that means, but you explain what it means. You explain that you'll cover their court costs, the incidental bills that are allowable in the rules. And I simply explained, if you want me to be your attorney, these are some of my limitations, and here are my strengths. And then I explained to them the limitations and the advantages of being in federal court, and the limitations and advantages of being in state court. And, at the end of the day, then they ask me, what do you think I should do? And I do tell them, because that's my job, to advise them, listen, I think you can win this play. You're no good to somebody if you just sit there and say nothing on this kind of issue, because you do know the court better, you do know the judge, you do kind of understand how it works where they don't. But this is what I think we should do. However, we still have a good shot at this other thing. I just think it's better if we do it in state court and let them decide.
Rachel asked a good question, because ultimately you've answered it. You did talk to the client about this, and would you recommend as a regular practice?
You must.
Even though you say you must, some people take the position that, where the client determines the objective. When big, lawyers can determine the means. This is in that gray area. Is this something that the lawyer can? A lot of lawyers don't even ask clients, at least in Virginia. They just choose state court because they don't like federal court. Oh, Ben, I never go to federal court because they're so mean. You know how it is.
I know how it is. I'm one of those that does tell my client.
Okay.
I get a little more direction than perhaps I should, but that's, for me, that helps me keep it clean for myself. Now, if they want to do something that I think is really, really a mistake, and it's like you say, it's within the rules of ethics, it's not about privilege or anything like that. And if they want to steer it in a direction that I completely disagree with, I'll tell them no, and that's not going to work for us.
Okay. All right, Lauren Stroyak has a question for you. She works for Billy Bright. Did you meet Billy Bright when you were in Virginia?
No, I don't think so.
He's a good personal injury lawyer, so watch out. She knows. She got $1 million verdict, or Billy got $1 million verdict this summer. Believe it or not, my son was the jury foreman. I haven't told you this story. Did I tell you that story?
No.
Okay, go ahead. And I didn't know about it. I was out of town. I came back and found out. I said, was there a paralegal for Billy Bright that had glasses? And I said, I knew who that was. Go ahead.
Small world. Ms. Bailey, I understand all your reasons for choosing state court in this case, but I just want to ask you whether you think you're doing a disservice to yourself and your future clients by not taking this opportunity to familiarize yourself with federal court. I understand that the mentor may not have, you may have been in a situation with the mentor where you were doing most of the work, but you did have a mentor in this case. You did have an opportunity for someone to guide you and give you that advice. I mean, you could have worked something out with the mentor to something as far as the workload. But as far as future clients and your future practice, don't you think it was a bit of disservice to yourself and your clients by not pursuing federal court in this case?
I don't, and I'll tell you why, because there will be plenty of opportunities in the future. I think the key here was the jury pool, and really knowing kind of what your county, I worked in Nashville once, and it was a given that you knew that Nashville juries in district court there were absolutely, your general sessions were absolutely going to give you the lowest rock bottom dollar for a plaintiff's injury case. And so we had to really find ways to get out of that court. But in this situation, the Dallas courts are favorable, and I'm not so sure based on opposing the manufacturer, the kinds of business they run in this state, and how well known they are, that a broader jury pool was going to do me as good in this case. So yes, I agree with you. I think you really need to think through, or I need to think through the future. It depends on the time space and where my jury's going to come from, and again the judge. You know, when you see who's going to be heading up the case, you know where you're going to file that case and what judge that's going to be. You can get a real sympathetic verdict or not. I can tell you right now, if it's an oil and gas case, I want to be in federal court. I I do really appreciate your question, because I will tell you, you face the reality of being afraid of what you've got to do. It's daunting to get out there and do some cases that make you nervous wreck. And you have to, that's where you pray through it, you breathe through it. I can't tell you how many times I was yelled at the first few months that I practiced, and by the end of it, it was good morning, Ms. Bailey, good to see you. So you have to prove yourself, know what you're doing for the little cases. Get in there with your teeny tiny cases, understand how to talk, and by the end of it, will be, well liked in the courtroom if you work hard at it. Be confident.